Hello and welcome to another episode of Calm the Conflict, the Art of Resolution, where David and I talk about the role of mediation in helping businesses resolve disputes. I'm a commercial litigation solicitor, and David?
Hello there. I'm also a litigation partner at EMW and an accredited mediator.
Today, David and I are going to discuss how the role of mediation can actually save businesses, especially from the point of view of a creditor company that's owed money by a company. And basically, you have one day of mediation. Your view is, David, as a mediator, use that day.
Absolutely.
Constructively. And ultimately, what can it lead to? It leads to parties basically walking away with a settlement or an agreement, and both businesses have been saved. Tell me a little bit more about your experience in resolving this type of dispute.
Oh, well, I've done loads of this type of thing. I did one a couple of weeks ago, which was a three-party dispute. So we had the funder was party A. They put a claim in against default. And then the second party brought in a third party blaming them for something as well. So we had a three-way dispute. But again, the whole point of this was one of the businesses, in order for the claimant, and it was a claimant on those occasions, to actually get anything out of anybody, there had to be a compromise in three camps. And everybody had to realise that actually if the claimant continued to press the button and the defendant continued to fight, no one was going to win anything. So the point of this podcast is to say, actually, sometimes it's not a case of fighting as a matter of principle, because you may end up getting nothing. And in that example and others that I've done, where you do have funders, banks or whatever, they are sensible commercial creatures, and it's not in their interest as a creditor necessarily to fold a debtor because they get nothing.
Yeah, that's what I was just about to mention, actually. It's not really, I see it time and time again, parties are reluctant to actually issue court proceedings and go down that route. Ultimately, they're owed the money. The other side is dragging their heels for whatever reason, whether it's cash flow, they're relying on new business coming in, they're waiting for all sorts of things to drop, or a supplier paying them because of the chain. And they don't want to go down that litigation route because they ultimately feel that actually, if they do, they'll end up getting nothing. So when they've got a mediation process that they can basically use, they can use that day because it's one day and it's cost efficient in the grand scheme of the whole process. Is actually best utilized on that day to get to the bottom of the disagreement.
Absolutely, and in the example I gave, the two defendants, if you like, it wasn't quite defendants, but the claimant had a bang to rights claim, as they say. We've got the agreements. You owe us the money. The defendant said, well, we don't because. The third party said we don't because. And the end of the day, both the second and both the other parties, other than the claimant, would have lost out. One may have gone pop. And then the claimant would lose, largely because there was only so much money in the pot. And on that occasion, this isn't always the case, but both parties decided to put their hands in their pockets and share the debt. So as we've discussed numerous times before, it's not about winning or losing. It's about both sides, everybody sharing the pain. The claimant took less. They took it by instalments. The defendants were able to meet those instalment obligations. And again, it was a sensible instalment that they could meet. We've discussed this in the past. There's no point in agreeing something you can't achieve. And that was part and parcel of the process. The claimant understood that. The claimant just wanted their money. The defendants had some merit, some didn't, doesn't matter. But the fact of the matter is they had to share that pain. They both chipped in, the claimant took a chip in, and everybody walked away with a resolution that worked, saving the businesses.
Save the businesses, ultimately.
Saving two potential businesses and saving the claimant a huge amount of time and money, which they would have spent on litigation, which we've discussed before, and not got any money at the end of the day.
And along the way, saved probably lots of other smaller businesses, because we don't see it because we're focused on our clients, but the impact of one big debt can have on the overall business, and then somebody isn't able to pay their suppliers. And like I said, that chain reaction goes all the way down because sometimes the smaller ones get neglected and actually they need that money more than anybody else. But just on offers and the day of mediation, using it wisely, do you think there is, who should put their offer forward first?
Okay, so we've had this conversation as well before. Who blinks first?
Yeah.
In litigation, it's obviously a strategy. Everybody says, let's see what they come up with. I'm not going to bid against myself. We need to see where they are. What are they, make us an offer. In a mediation, it's a very different process because actually there's strength in starting that ball rolling. The mediation, the one that I did that we're discussing, was actually, we got to the offer stages literally immediately. There was no point. The claimant is saying,
"We know." Good day for fees for you then.
There you go. An easy day. Very, very. It so happened. It took a long time to get the paperwork sorted, but ignoring that. There wasn't that fact finding necessarily. Okay, the claimant knew they were there to do a deal. They were there to do a deal. They were prepared to compromise. They were not prepared to give the first figure. It was down to the other parties to do it. So most of the time was discussing between the other parties how they're going to share it, who's going to contribute, and that meant the two businesses had to take a sensible view. So as part of the process, which we could do in mediation, which you can't do at trial, is we agreed that actually I had the two directors from the non-claimant parties come and talk to me. And that I stepped out of the room. They spoke to each other. Whatever they said worked. They then had another further couple of chats with each other, which can't happen at trial, saved a huge amount of time, huge amount of money, and they managed to resolve it themselves. And, I just sort of was feeding the process. So I kind of stepped back and let them talk, which is often, again, another thing that needs to be done. It's doing the honourable thing, face saving, avoiding problems, and keeping the relationship alive, because the parties can now talk to each other and there may be further opportunities down the line. So why not?
No, and I agree with you. And also, I think what happens is having that independent mediator there, I think sometimes it encourages parties to have that chat. Otherwise, they probably wouldn't do that.
I think absolutely right. The process is built for that.
Yeah.
But I think, in my experience in mediating and doing mediations, the job of the mediator is to get to offers, get to a settlement. Let's see where we are.
Is there any advantage in putting an offer forward first for any party or not?
I think there is. So in this example, that there is if the paying party doesn't have the money that the claimant wants. Okay, there's no point in wasting time. If claimant A has unreasonably high expectations and the paying party can't afford to pay it. Okay, what's the point? So what we did there was we spent time with the payer discussing what the payer can afford, why not, and how to put that information to the claimant or the creditor so that they understood the position, saw the position, and then we could structure a deal, which meant me then spending more time with the other two parties rather than the creditor, trying to put that bill, that to bed. So that, as I say, that wouldn't have happened but for mediation, and that is the whole point of a mediation. We've saved the business, we've saved face, we can move on. It was a settlement that was achievable. They could do it, and everybody was happy. Not happy. Everybody was.
I was going to say, is anybody actually ever happy truly parting ways with money? But
fair point.
But it was a sensible resolution, like you said. It was practical. It was sensible.
It works.
It saved the business.
It saved the business. It saved the debtor business. It saved a potential huge escalation of costs with lots of arguments that were being raised, and it got the money in the bank for the claimant, lump sum up front, and then instalments over time that were secured in certain ways. So yeah. It is very sensible to do.
So again, it just highlights that the power of mediation.
Absolutely.
And why mediation works, how it can help you as a business owner, as somebody that knows somebody that's going through a dispute. Use mediation as a tool to alleviate those pressures in going to court, the time, the money that's spent. Thank you so much for joining us once again. We will be back, David and I, with more episodes because we can talk about mediation all day long.
We do.
We really can. No, don't forget to like and subscribe. You can get the podcast on any platform of your choice. So do follow us so you can keep up to date. And again, if you've got any questions, do send them through to us. Thank you so much for listening.
Thanks very much.
Thank you for listening. This podcast was brought to you by Right Here Creative, a video creative agency based in Oxfordshire. Check them out at rightherecreative.co.uk.